Yes, sir.
For delivery of judgment, item 36.
In the circumstances, the order of the tribunal dated 3/6/2020 passed in TA number 62 of 2009, rejecting the petitioner's claim is not sustainable both in law and on facts of the present case. Accordingly, the same stands set aside and passed. Resultantly, it is held that petitioners are entitled to a grant of temporary status from the date they completed 240 days of service in accordance with the scheme 1989. The respondents are further directed to confer such status with consequential benefits. The respondents shall thereafter consider the petitioner's case for regularization in terms of scheme 1989 and in the light of the principles laid down in Jaggo and Sripal and daily rated casual labor supra. The entire exercise will be carried out within a period of 30 days from furnishing a certified copy of this order before the 60 days from furnishing of a certified copy of this order before the respondent competent authority by the petitioner. Accordingly, the present petition stands allowed to the extent indicated herein above, parties to bear their own cost.
Deeply obliged, Lord.
I agree. Reasons are in the preceding paragraphs.
In fact, in one of the cases recently, I appeared before a single judge for casual workers. The learned single judge also has held the same view. That, of course, my lord, I was appearing for a petition.
This is no sympathy, but
My lord.
the line of decisions.
My lord. The jurisprudence, of course, is shifting in this direction. Post Omade.
Sorry, आपको मैं भी कर देता हूँ कर दिया कस्टम सुनता
Already the regulator is going with the shipping lines of the that was repal.
double two or yes. Give it to
Yes.
all right.
Adjournment request, if any, from item number 1 to 8. From item number 10 to 17, adjournment request. From item number 19 to 28.
Item number 21, Lordship, kindly matter may be adjourned for 2 days.
21.
Lordship,
2 days. It's difficult. 2 days is difficult.
no, only for 2 days, Lordship.
Only for today. All right. Tomorrow, how many matters we have? All right.
Obliged.
At the request of the land council for the appellant, let this matter come up for consideration on give a date tomorrow.
Would due consent from the other side of the agreement, item number 26 to 29. I have.
You have circulated the
Yes, madam, I have circulated.
tip has been circulated February.
Immediate convenient to my learned then.
Date will fix on January.
January, our calendar is full. It goes in February.
13 February.
13.
Obliged.
Or if you don't want adjournment, don't consent.
May please your lordship this matter, item number 23, may please your lordship this matter may kindly pass off for the day.
Item number?
23.
No. Otherwise, we disturb the calendar. Either you seek time or you argue it today. We'll help you out.
Because senior is out of station.
No, that is no problem. We can adjourn the matter, but don't ask it for tomorrow.
Not tomorrow, day
Your lordship on 19th
19th
19th of
of
December.
no,
January.
January. As per it, this is item number 23.
Yes.
You're challenging the remand.
No.
He's a workman. I mean, case can go here or there. You should argue the case. And anyway, as prayed for on behalf of the petition appellant,
Yes.
as prayed for on behalf of the appellant, and agreed to by the council for the respondent, let this matter come up for consideration on, we have a date in January. January also is full, no?
8th of January.
Obliged. Much obliged.
From item number 30 to 35, adjournment request.
May I please, your lordship? Lordship, I beg to mention item number 30, lordship. We have instruction to withdraw this matter.
You have instructions to?
Withdraw this matter.
All right. Can I have your name?
I mean, Miss K. Murali.
Hmm?
Miss K. Murali.
And you have been instructed by Mr. B. Kaushik,
Yes, lordship.
Mrs. Swanso, MS Swanso, learned advocate, on instructions from Mr. B. Kaushik, the advocate on record, seeks permission to withdraw this application. Dismissed as withdraw.
Much obliged, lordship. May I please, lordship? Lordship, I beg to mention item number 31. Lordship,
31.
31. Engaged counsel is out of the station. Kindly adjourn the matter for today, lordship.
This compassionate appointment after 15 years. And you're taking time again. Anyway, as prayed for on behalf of the appellant, re-notify February.
Full name.
2nd of February. Any other request?
Obliged, lordship.
May I please, your lordship? Your lordship, I beg to mention a matter for urgent listing for tomorrow. The urgency here, your lordship, is that in this particular matter, there are 3 simultaneous proceedings. First, your lordship, is a liquidation proceedings before NCLT Delhi. Second, your lordship, is a section 95 invoked by the bank, which is pending before NCLT Guwahati, and there are recovery proceedings before DRT. Now, your lordship, my urgency lies on the fact that before NCLT Guwahati, the bank has invoked the assets of the personal guarantor, which is a part of a settlement deed which is listed before NCLT Delhi tomorrow. Hence my urgency, your lordship.
That we can't, there'll be overreaching. There'll be an overreach if we pass any order there.
Your lordship,
You can always engage the council in Delhi.
no, your lordship, the invocation is in NCLT Guwahati.
Oh, come on.
All right, your lordship. Much obliged.
Inform the other side.
Yes, your lordship.
Daily list for orders, item 1.
May it please your lordship. This matter is so motu PIL, my lord, pertaining to submission of progressive report construction 4-lane work Jatinga to Harangajau.
Sorry, we
Then-
didn't hear you. We were distracted.
This particular Sumotu PI is to file progress of the work from Jatinga to Harangajau.
Yes.
That is up to 15/7/2025. I have
No,
filed.
we're in the month of December.
No, that's
What has happened by now?
now by now, yesterday only, because up to 15/7, I have already yesterday by phone, I have queried them. They have given me this information, but it is not signed. That is, may I pray for to file on this all record up to 30th 11, that is November.
Now, what is the status? Just read out from
That
there
is
so that we are
that is
satisfied.
the only progress, my lord. Last occasion we have shown is 61% status. Now it is progress to 86.21. There is a substantial progress.
It is 6.2.
That's right. And 2-lane will be completed by January 2026.
That deadline you're going to.
Because now we are doing, because this is the season. We are construction season, because earlier this is a rainy season unless we are unable to do this. Now it is a season, that's why we are progressing fast, my lord.
East-west corridor. To recapitulate the facts of this case. This PIL was initiated to address the prolonged delays in completing a critical section of India's east-west corridor, specifically the Silchar, Harijago, Aflong stretch. Harigajo. Harangajo, Aflong stretch. This highway project, part of ambitious national highway development project overseen by National Highways Authority of India under the Ministry of Road Transport and Highways, bracket MORTH, Government of India, was launched in 1999 with the goal of bridging the infrastructural gap between Northeast India and the rest of the country. The vision behind the corridor was to foster socioeconomic growth in one of India's most underdeveloped regions by providing modern road connectivity, which would have facilitated traffic in southern Assam, Manipur, Mizoram, Tripura, etc., and would serve as a vital alternative route to Guwahati and mainland India. Reducing dependency on the fragile and often disrupted National Highway number 6 and the Badarpur-Lunding railway line. An affidavit was filed in the month of September.
No, it is it is the 23/7/2025 in July. It was took,
The
But
the
not
affidavit
listed
filed in
then.
September by the project director, PIU Haflong NHI, indicates that 61% of the work has been completed. The affidavit incorporates phase-wise work progress with respect to major works, road works, culverts, minor bridges, major bridges, elevated structures, etc. The entire at that time, by that time, when the affidavit was filed, the two-lane road for two-lane road for connectivity had not been completed because of weather conditions, difficult terrain, and some of the structural challenges. However, it was expected by the authorities that the project would be completed by January 2026.
it is only 2 lane mill.
Mr. Barua, learned you're standing counsel for?
My lord,
You're standing counsel for NHAI.
NHA.
Mr. C. Barua, learned standing counsel for NHAI / respond number 2, has submitted today that he has received fresh instructions
There's one side like in
that
between that.
that more than 80% of the work has been completed.
Yes, my lord, that is,
And there is every possibility of the NHAI meeting the timeline of January 26th for
that is,
completion.
my lord, only two lane, my lord. That is a 4 lane. We are
When
earlier-
will you complete the entire work?
No,
Then we'll
entire
not say that.
project by, we are expecting July, by July
What did I say?
2026. Entire project, entire, this 2 lane will be by 26 January.
What have I said? Of January 26 for completing the two-lane road
Yes, my lord.
connectivity. The entire work is expected to be finished
July
by July 2026.
26.
Mr. Barua shall put this on record by way of an affidavit by the next date and shall also intimate to us the current / updated progress report in the
My
work,
lord, my lord.
February.
I'll give up,
You give me
November. I'll give up to November.
January.
when you file February,
When do, February? Yes, my lord, I'll give.
you must give a completion report by February.
Oh, my lord, yes.
16 February.
Obliged, my lord.
Much obliged.
Item number 2.
In this case, your lordship, I was supposed to file an affidavit, your lordship, by today.
You were
But
supposed to.
somehow, lordship, it is my fault, your lordship, I failed to communicate in time this Order, your lordship.
So Mr. Bodhakur, what time do you?
Your lordship, next week, your lordship.
Next week, we are off leave.
Then on the first week of January, your lordship. By that time, your lordship, I will file.
At the request of Mr. S. Bodhakur and Standing Council for the missing autonomous council, bracket respond number 3. The matter is adjourned to so and so date in January. So and so date, matlab na? On such and such date, which will tell you in January.
Not 18/9.
January 2026. For him to file affidavit, for him to file the required affidavit as directed by the spot by the order dated 22/10/2012.
Deeply obliged. 8 January. Item 3. 8 January.
Yes,
Yes, ma'am. Yesterday, my lord, the DEO, concerned DEO has sent the gradation list to the directorate, my lord.
yesterday,
Yesterday, my lord.
So the
Very
gradation
late.
list is already prepared in the year 2021, my lord. Why new gradation list is prepared, my lord? Already roster registers also approved, my lord. Kindly say in the order, my lord.
the and you comply with the judgment
Yes,
in letter and spirit.
yes, my lord.
We are giving you further 2 months' time.
Yes, my lord.
Do it by that time.
Yes, my lord.
The Mr. Katania, learned advocate for respond numbers 1 and 2
1 and 2.
submits that the DWEO of the Hailakandi district has submitted his report to the Director of Elementary Education regarding the gradation list of assistant teachers of government senior basic school under Hailakandi district. Rest other DEEOs have submitted the report. Mr. Khatniar, learned advocate, submits that by the next date, the judgment of the learned single, the judgment of the court, judgment of this court shall be complied with. Let this matter come up for consideration again under the same heading on on some day in March, by which date an affidavit must be filed by respondent number 1 and 2 that the judgment in question has already been complied.
9th March. Item 4.
My pleasure, lordship.
Yes,
Also, I have taken steps upon the respondent number 10, lordship.
yes, what happened?
And also, as per office note, AD card is received without any signature. However, the service report is still awaited, lordship.
My lord, I am appearing for respondent 10.
He's appearing.
Yes, my lord. My lord, but the only problem is the service copy that I have been served, my lord. Few pages are missing, my lord.
Give him a complete set
Yes,
of
sir.
the, what is your name?
A Deka, my lord.
Huh?
A Deka.
Mr. A. Deka, learned advocate, has appeared on behalf of respondent number 10. So the pleadings therefore are complete. The service therefore is complete. Let this case be listed under the appropriate heading of admission on January 1st day. So the land council for the petitioner shall furnish a complete copy of the brief to Mr. Deka, learned advocate for respondent
Sir, I'll file my affidavit on the.
during the course of the day. So, respondent number 10 may file his affidavit if so deemed necessary by the next date.
9/1. Item 5 and 6.
Item? Yeah, yeah.
In fact, my lord, review filed by the state was listed 2 occasions. Bench was constituted, but unfortunately could not hold the court, my lord. That is why on 26/11 and previously
Who
on 9.
hears the review?
Sorry, my lord.
Who will hear, which bench will hear the review?
My lord, Justice, along with my lord, Karnataka 80, my lord.
Sitting with me.
Yes, my lord.
Was that judgment delivered by us? No,
No, my lord.
some other
Yes,
composition.
my lord. On 26/11 and 9/11,
You have to wait for some time. Let's see what happens in review jurisdiction. Yeah, as. prayed for.
Review, lordship, we are not served copy, lord.
Yes, your lord.
I will serve.
We
a
are not
copy.
informed.
When will you serve?
No, my lord,
That has
because
been
in
not been
review
listed.
normally, my lord, we
You
have,
serve them in advance.
Yes,
So
ma'am.
that they are prepared.
Our name was not shown, Lord.
that I can
What
do.
is it?
That,
Serve them in advance.
yes, my lord.
Not even. delay.
And when the matter is listed on the next date, we are keeping it in February.
Yes, my lord.
By February, either you have an order from the review court. January will not be there. We are keeping it in first week of March.
Yes, my lord.
Yeah, as prayed for. On behalf of, yeah, respond number,
One, my lord.
as prayed for on behalf of respond number 1, let this matter come up for consideration. First week of March.
Oblige, my lord.
By free.
I got
If not. Item 7 to 9.
Good. Yes, Mr. Das.
But,
What have you filed?
my lord, in this matter, there was a SLP before the Honorable Supreme Court. And the Honorable Supreme Court has been pleased to reverse the order of the division bench and restore the order of the single judge.
Okay.
May I please that?
Are you aware of this?
You are
Lord,
present
today
before the Supreme Court.
Today morning, I got the copy, my lord. It was uploaded yesterday, my lord. I need some breathing time, my lord, so that I just,
He was present before the Honorable Supreme Court, my lord. Para 18 page 10.
my presence is all right, but the thing is that, my lord, this
Para
order,
18 page 10, my lord.
Supreme Court, Honorable Apex Court interpreted Rule 4. And Rule 4 is, my lord,
Whatever it is, we
I understand, my lord, lordship, what I,
analyze the judgment of the Supreme Court. Judgment of the Supreme Court, it has to be reversed. Then perhaps you have to return, give him all persons. This was the cutoff date 30th of March.
it is exactly similar to the Rule 5 of the state rule, my lord. It has got serious, I'm not
We
arguing.
have space to discuss all this.
Sometime this matter may be taken up immediately after the vacation, my lord. Lordship will give me some breathing space so that I can just discuss with the authorities and,
You are left with no choice.
Lord, we are
What discussion?
seriously.
You have to
my lord,
pass an order.
Look.
You have to comply with this judgment.
my lord, that's true, but
So keep it next week. Take instructions.
first week of January, my lord, because we are sincerely contemplating to file a review, my lord. That is my,
The learned counsel for, what is your name?
Jay Patwari, my lord.
Mr. Patovari, learned advocate for the respondent. Number?
Sole
Sole respondent has produced before us a judgment of the Supreme Court in civil appeal number 14559 of 2025, whereby the judgment of the division bench of this court not allowing the benefit of pay revision to the respondent has been reversed. Mr. Das, learned advocate for the appellant / Assam Power Generation Corporation Limited, seeks some time to look into the matter, take instructions and inform this court about the steps taken for compliance of the judgment of the Supreme Court, which has been produced before us today. Let this matter come up for consideration on, we'll keep it in the first week of January.
6 of
First week
January.
of January.
My lord was pleased to pass some interim order.
You can decide it, we can keep it on the last day.
no, kindly, my lord, first week of January, my lord, in the meantime, let me have some.
There is a specific direction, we can't do it. In fact, we.
So far as the money is concerned, they have already got the money. All these persons, they have already got the money, my lord.
And the pension-
Money was released.
All right, so you have the order, Mr. Patavari, in your favor, no?
Yes, sir.
So January
I'm
1st.
not objecting.
6 of January.
Those documents may be kept on record.
We have kept it.
Deeply.
Highly.
Item number 10.
May I please, your lordships?
Hmm.
Lordships, office note dated 3/12/25 indicates that neither the service report has come, nor the unserved notices have come back.
Awaiting the report regarding service of notice on respond number
Only the sole
on
contender.
the sole respondent / proposed contemner. The matter is adjourned to February.
Lordship, do I need to take further steps now or should?
No, let us wait.
Lord,
4th of February. Item 11.
Who is, which lawyer is appearing for the state government?
Item 10.
Where is Mr.? MS Sharma. Very. Why do you bury your head when the state is looking, when the court is looking for the state council? We are not going to put you in any unanticipated trouble. But when we look for- But when we look for a state, especially when the Advocate General also is sitting in the courtroom, you should immediately mark your presence, no? No, we don't require you, Mr. Advocate. You take a seat. She is good now. There's a contempt matter where notices have gone to Deputy Commissioner Kamru. He has not received it. Inform him that he should accept.
I will, Mel.
We have kept the matter in schedule. Look up the matter, inform the Deputy Commissioner.
I will.
He is under threat of contempt. So he must respond, no?
I will.
All right.
Court of February.
Take the number of the case. Talk
I
to the
will.
counsel.
I will do that.
Item 11,
So there is a delay of 115 days.
Coming for the first time.
No, lordship, earlier notice was issued.
I'm applying for respondent, my lord.
Yes.
I have no objection, my lord.
Like no, practically no objection. 115 days delay condoned. Appeal to be processed.
Much
16 February.
Much obliged, lord.
16 February. Item 12,
Heard both. Parties. Yes.
There is a delay
Objection
for this
filed, but we
application.
are inclined to condone the delay.
Lordship may condone it, but I'll just point out something, my lord.
117 days is nothing. We are
No, my
condoning.
lord,
We are
the review was dismissed on 10/5/24.
delay condoned.
My
Mr.
lord.
Gogoi.
Obligation.
If you really object to such condonation, we will be very strict with your condonation.
My lord.
17-2. Item 13,
Lordship, in this case, the state has filed the appeal
Hmm.
with a 160 days delay. We have tried to take the steps, but
Told one of your state council that you don't object to the condonation petition of private persons. We will be.
here the issue is different, Lordship. The address,
But then the notice has to be served, no?
yes, the address is not found. So Lordship, my prayer is that Lordship will allow us to give paper publication.
All right. Though notices were issued to the sole respondent in the matter, but the respondent is not to be traced. Mr. Advocate General appearing for the applicant plus state submits that paper publication may be permitted so that the respondent gets notice of this proceeding. Where is allowed, on deposit of requisites in the registry, a copy of the notice shall be handed over to the counsel for the appellant, who shall get it published in 2 state dailies, one in English and the other in Assamese. And after its publication, shall submit a report regarding the same along with a copy/clipping of the newspaper publication. Rule is made returnable by so-and-so of March.
Deeply obliged, Lordship.
9th of March. Item 14,
May it please your lordship. No, yesterday we have filed an objection, my lord. This is not on honorable court record, my lord.
It is here. Yes,
455 days. delay,
that's
lordship.
a big delay.
Yes, lordship, but the appellant before your lordship is a mother of a special child. 50% disability was diagnosed.
For the reasons delay known.
Much obliged.
Send it.
yes, Lordship.
Lordship, SC Finance will represent in the cause list, my lord. Though SC Finance is a party, their name is not reflected in the cause list. I have. Obliged, lordship.
Item 15,
Lordship, in item 15, I had taken the liberty to go through the service report, Your Lordship. It appears that service upon respondent number 1 and 2 is complete, Your Lord.
awaiting the appearance of respondents number 1 and 2, who are married couple.
Lord.
The matter is adjourned to January. If they don't come, then we'll take,
Lord.
2nd February. Item 16.
My lords, I'm appearing virtually in item 16. Am I audible to my lords?
Yes, very good.
My lords, before the state submits, I have a request in item 16, my lords.
Lordship,
My lords will
I
recall
also-
that in the last order, my lords had directed the appellant, directed me to deposit 11,000 rupees as court fees against the grant of the probate certificate. My lords, we went to the trial court. We deposited 11,000 rupees, but the honorable trial court now has not granted me the certificate on the ground that there is no express direction to grant the certificate. There is only a direction to pay the money. My lords, this has led to a very precarious condition because despite the probate proceedings being in my favor, despite me depositing the money in the trial court is not giving me the certificate on the
Certificate of
ground
what?
that the probate certificate, my lords. We have deposited the court fees of 11,000 as directed by this honorable court. My colleague will just hand over the.
Then cancel it.
My lords, in fact, we are also.
Put it on record, we will set it aside, we will put the court under an explanation. Why is this? What is the purpose of depositing court fee?
Exactly, my lords, this is the argument I made before the honorable trial court. I said that the whole objective behind depositing the money was to give me the certificate.
But
the
there is-
trial court,
but there is-
the
but
trial
there-
court is saying,
Just a minute. But there is no declaration that no certificate shall be given.
no, my lords, the understanding was that I will be given the certificate at 11,000
What's your
rupees.
name? What's your name?
From
You-
Mr. R. Chaudhary, my lords.
Mr. R. Chaudhary, learned advocate for opposite party number 1, submits that though the court below has permitted the deposit of 11,000 rupees as court fee, subject to the final outcome of IA bracket civil 3261 of 2025, pending before this court, but has not given the certificate expressing given certificate, citing the reason that there is no express order of this court dated 29/10/2025 to issue the probate certificate. We fail to understand as to the reasoning given by the trial court, reasoning given by the court below in not giving the probate certificate when a direction was given to accept the court fee of rupees 11,000, which would be subject to the outcome of the petition, which would be subject to the outcome of the case pending before the High Court. It is expected of the court below to immediately grant the probate certificate with a caveat that it will be subject to the writ proceedings before this court. A copy of
Absolutely, my
this
lords.
order-
I'm so grateful, my lords.
Just a minute, we are not yet complete. Let a copy of this order. The learned counsel for opposite party number 1, Mr. Chaudhary, learned counsel for opposite party 1, shall place this order before the learned court below for compliance. Yeah, what have you done? That
Lordship,
amendment has to be made, no?
Lordship, I am very, very sorry, Lordship. I am on behalf of R.K. Bora, Lordship. Instructions yet to receive, Lordship.
Anyway, we'll see it on another day. Today it is only for the IA.
Lordship,
Do it by the next day. Don't create problems for us.
Lordship, it would be for the applicant, your lordship.
All right.
Lordship.
Deeply
Deeply obliged, my lords. Deeply obliged.
Next date, re-notify on so day. Date March.
5th March.
All right, place that order before the court. You will be granted a certificate. We are not doing anything without it being
I'm
brought
so
on
grateful, my
record, we
lords.
have done that.
I'm so grateful, my lords.
Item 17.
I am so grateful, my lords.
Early hearing.
Early hearing, Your Lord.
All right. When do you want it?
Last में थे.
Huh?
Last में थे.
February, March,
January last.
January,
January
late
possible.
January.
Lordship,
Alright,
except
application allowed.
Lordship, except 5th of January, Lordship.
5th is too early. It'll be after the holidays. Good time for you to make preparation.
Deployable.
Application allowed. To be
22nd January.
to be listed
22nd.
in priority on so and so date.
Apply last.
Takes a little.
Item 18.
What you get.
My lord, there's a delay of 40 days of preferring the appeal. Notice has to go, my lord, to
Because of the private respondent. There's an application seeking condemnation of delay of service. Let notice be issued to response number 1 to 7 on steps being taken by the applicant within a period of 2 weeks, both modes, returnable February and.
My lord, similar matter is pending on the.
Just a minute. 4 to 7, who accepts the notice? Mr. Das, you.
Yes, my lord. 4 to 7, I can accept.
Give the file. Yes. Let notice be issued to. Oh, just
My lord, 3 also, my lord.
let notice be issued to respond number 1 and.
Notice will only go to respond number 1, my lord.
Only to one.
They let notice be issued on respond number 1 on steps being taken. Notice to response number 2 to 7 is accepted by Mr. H.K. Das Ladedat.
3 to 7, my lord. And so forth.
2 is by?
2 is by the
3 to
government.
7 by Mr. Das. Mr. Notice to respond number 2 is accepted by as borrower. The land council for response number 2 to 7 may file their response to the application if so deemed necessary by the next date.
My lord, similar matter where has preferred an appeal, and that's fixed on 9th of January. By the private respondent, man.
Let that be decided independently of this.
My lord.
This goes in February or March, February.
Highly of it.
25-2. For admission, item 19.
Yes.
My lord, the petitioner has,
No, because that price is not acceptable. Yes.
my lord, the petitioner has filed the petition, making the prayer only for compensation because he said some extra land, additional land has been, my lord.
Oh, that's the main issue.
That's the main
contention.
Now, my
So
lord,
what do you propose?
my lord,
They are not agreeable to the price of 7,50,000 per bigha.
that's right, my lord. But earlier it was fixed 2,50,000 by the government itself. Lordship will find 2 documents. The government
the
said
option-
2,50,000. We agreed to see 7,50,000.
That's right, but the option is with the landowner, no? Either you acquire and pay according to the 2013 Act.
No, I can't, my lord, because the Lordship will see section 24 of the 13 Act. It says when the award is, my lord, given and the payment is made, possession is taken over, it is only under the old Act, Lordship
Sorry,
24.
no, that is a wrong understanding of section 24.
My lord,
Indore, what is that case?
Indore has said, my lord, this. Indore has said and my lord has said, and after the possession is taken over, even the title is, my lord, the landowner will not have the title because it is vested on the government. We cannot purchase even. That's the case. So, my lord, the land single judges, all procedure.
The difficulty is this, you consume the land of the respondent.
No, that's.
And you never paid for it. You had not even acquired it. You have constructed a building. Now, after all that inquiry, of course, there are certain issues.
My lord, if he.
Can you just hear the court? We are concerned with this. Because, there are other issues which need to be gone into in appeal. Whether under Article 226, exercising writ jurisdiction, whether this could have been ordered.
That's my lord, that's my humble.
Without the respondent having exhausted the remedy. under
Exactly,
section
my lord. That's why my submission.
That also after 15 years, but that's.
That's exactly, my lord. and he has a remedy.
But the difficulty here is that we are not going to get into all that because everything is overshadowed by the principle enshrined under Article 300, capital A.
My lord, all procedure are followed. Section 4 notification,
No,
section 6.
There is no dispute with regard to these lands not having been acquired. Can you question that?
No, it's a vast area land, including this land.
So for this was not acquisition, compensation not paid.
That's right. That's the only one. Compensation net paid, and we are ready to pay compensation as paid to all the landowners.
That is not agreeable.
All the landowners. Even is.
Yes. Why don't you accept the compensation?
My lord.
It will run in litigation.
My lord.
There are other aspects to the matter.
My lord, let me submit, my lord. First of all, my lord, this is an access land. It is not in the notification. It is access land. It is not in the notification. If by the notification only 7 losses has been taken, that amount has been paid through the court, my lord, because they were withholding that amount. Now, after the due inquiry, it was found that this is an access land, 1 kata 10 losses they have acquired.
The question is,
now, if they want to acquire the land, my lord, now they should come under the new act, my lord. And they should give it. That option was given to them. Either you purchase it or you give the as per the new act. They are not complying with it. They are insisting on the old act.
is there an updated, Mr. Nath, is there an updated circle rate available for that area? Updated, not of 10 years old.
That I have to take.
Now you don't expect, see, we will not revert it. Because depots have been built.
Yes, ma'am.
You have approached after 15 years. So you can't have it in that aggressive way that this is your land, you must either acquire or pay compensation according to 2013 Act. Now that right you have, but we also can find out that there was a delay from your side.
Yes.
So therefore don't expect sky high.
No, my lord, we are not on that, my lord. We are not on that. Actually, if your lordship goes through the judgment of
you are exactly on this.
No, my lord, I'm not on that. My lord. What I want, that there'll be a notification.
You are exactly on the quantum.
My lord, what I want is that.
See, what happens is that we will, if you insist for this, we will admit this, analyze whether the single judge was correct and stay the operation of the impugned judgment.
My lord, what I am submitting, my lord, let there be a notification of acquiring the 1 kata 10 losses. Because as per the indoor development, there is a mandatory, my lord, for notifications.
Mr. Bhattacharya, I am very sure that if they acquire the land,
yes,
even with 2013 Act,
yes,
you will get lesser than the price which they are offering. We'll ask them to upgrade the price.
Yes, lord, that will go.
Hike the price and be done with it.
Yes. I am agreed to that.
Yes.
Yes, my lord.
Mr. Roy.
My lord, the government can, the collector can help your lordship to get the some evaluation. We are not against my lord paying, my lord. He is asking for, my lord. That's why. And his prayer was only to the amount of compensation, nothing beyond that. He did not want, my lord,
What is the price that you will settle for, Mr. Bhattacharya?
My lord, if I go by the market rate, it will be too much, my lord. So I doesn't want to bother them, my lord. So within medium path, we have to come, my lord. So if your lordship says about the delay, there is no delay on my part because when the amount was not given to me, when they have acquired the 7 losses land, I approached them, the DC, and asked them to give my land value. Then the DC has raised all this question. It is only for 7 losses, not of the entire land. Then I have to come to this court.
What exactly would be the measurement of the land for which you have to be compensated?
1 kata 10 lesser, which is not in the notified. The access land. Only 7 losses they have taken.
Lesser. Almost 1.5 katas.
Because at this stage in the market rate.
So therefore, you tell us what will satisfy you. We'll put it to the government.
My lord, then I have to ask my client, my lord, how much she.
You tell your client.
Yes.
That, should not
But I will pray, my lord, let it come in the middle path, not the market rate, Not this side, my lord, in the middle part. There were, earlier it was 7 lakhs. Let it be somewhere about 15. Because one
There
kata
are-
10 lakhs.
See, we look at it from the angle of Article 300A, but also Article 39B of the Constitution, resource distribution.
Yes, equal.
And now, they're thinking Constitution 39B.
Yes.
If we apply that, then possibly we'll have to take a lesser, I mean, a path which is less frequented, less than middle path. So you tell your
But the
client that-
question is, my lord, whether there was a notification or not, that is the issue, my
That's
lord.
right, on law,
Because the
we don't have anything.
Indoor
to say.
development has said to acquire the land, there must be a notification. And the notification should be as per the new act, my lord. So if the new act comes in, my lord, then it comes to, the calculation is there.
What is that calculation? Would
About
that be-
4
would
times,
that-
my lord, rural area 4 times of the fixed by the deputy commissioner.
ये पुराना है 39B है. That the ownership and control of material resources of the community are so distributed as best to serve common good. Will enforce this. So now the state is not bankrupt. The state shall give you.
Yes.
But don't ask for too much.
No, I'm not asking for too much. I said was
Location in some village,
As per
some
the
area.
general valuation, the value has been assessed in 2024 as 7,60,000. One kata.
No, suppose this has to be acquired. If they don't accept, if they don't, you can't coerce him into selling his property. If it has to be acquired under 2000, it will be done only under 2039. There the rates are fixed. So either you give him that rate or slightly less, but you can't ask him to settle for 7,50,000. So just find out, we'll put that offer to him and we'll be done with it. It's a very old matter, therefore we don't, not old so far as this case is concerned, but the acquisition was long time back. All constructions made, everybody paid. It was only later detected by Mr. Bhattacharya that some part of it has wrongly. No, you ask.
But it was detected by the deputy commissioner, not by me. I went for compensation of 7 lassas, my lord. Then it was discovered that they have gotten the access land. Then I made a claim, my lord. Learned single judge has made an inquiry to this aspect, my lord, and the government has filed an affidavit to that extent and state, yes, this is the access land they have taken over. It is the state government affidavit, my lord. It is not the acquired land, my lord.
And on the Food Corporation of India and another have challenged the judgment dated 18/12/2024 passed by a learned single judge of this court, directing the District Commissioner Kamru Rural at Amingaon to demarcate the land measuring 1 katta and 10 leshas under Dag number 1693 of Patta number 331 of village Changchari, Moza Sila Sanduri, Bhopal, under Uttar Guwahati Revenue Circle in the district of Kamrup (rural) Assam, and hand over the possession of the same to the respondent / writ petitioner, and to further assess the rental amount for the period from the date the land in question was handed over to the appellant till the date when possession would be handed over to the respondent, and upon such determination being made, the same be sent to the appellant for due payment. The appellant for due payment. The appellant was also made, it was also made obligatory for the appellant to make the due payment to the respondent. The dispute, next part, the dispute revolves around a land acquisition in 2007 for constructing an FCI food storage depot at Changsari in the Kamrup district of Assam. Approximately 27.39 hectares of land was acquired by land acquisition case number 104. There was a subsequent acquisition in LA case number 3 of 2012, whereby more than 7 bighas were also acquired, which included some portion of the land of the respondent. On the acquired land, the appellant had constructed the depot with boundary walls, which depot is operating for public distribution of food grains. It was only after 15 years of the acquisition that it was learned by the respondent that she had not been paid for 1 kattha, 10 lechas of land, which had been acquired. It further transpired that the same was never acquired, but possession was taken over by the estate and handed over to the appellant. The only option then before the state and the appellant was to either acquire the land afresh, which would have been possible only under the Land Acquisition Act of 2013, or purchase the land and pay the rental of the land for the period for which the appellant was in possession thereof. The learned single judge, therefore, in our estimation, is justified in giving such direction to the appellant and the state. It appears from the records that the appellant and the state expressed an intention to purchase the land from the respondent and offered a price of rupees 7,50,000 per kattha. 7,50,000 per kattha.
For the land, my lord. For the entire land.
What did I say?
25 lakh per bigha additional hill.
For the 7,50,000 for the land so acquired, for the land so used, which had not been acquired earlier. Used but has not been acquired earlier. The aforementioned price is not agreeable, is not acceptable to the respondent. In all fitness of things, we deem it appropriate to ask the learned counsel for the respondent and the appellant and the respondent as to settle for a price which is reasonable, in accordance with the circle rates, and would not be lesser than the price which would have to be given to the respondent if the land is acquired under the 2013 Act. The learned counsel for the parties shall inform this court by the next date as to the price settled, as to the price on which as to the agreed / negotiated price. Let this matter come up for consideration 15 days, January.
Okay, yeah, after 15th, I'll be out after
Let this
15th.
matter come up for consideration last week of January.
Oblige, your lordship.
30th January, 30.
There'll be no other option. If he doesn't accept that price, then you have to acquire it. We don't find fault with the judgment.
That's
Right, so
I
we will be using 39B if Mr. Bhattacharya, becomes greedy.
Item 20.
Oblige, your lordship.
Parents need to be at the fourth, नाम याद नहीं रहता है। इसमें भी हम लोग भी अभी थोड़ा तो हो गया। दूसरा तो हो गया। वैसे वो होते ही,
Wait, your lordship.
I don't agree. What is the stage of the departmental proceeding?
Inquiry has not been started yet, my lord.
Mr. Gogoi,
My lord.
now you want us to read literally the OM? Not at all.
My lord.
Not at all. We are not agreeable with this judgment.
My lord, regarding my.
You're keeping him under animated suspension for so long, and you're not even appointed an inquiry officer.
Inquiry officer has been appointed,
No,
but they have
appointed,
not
my-
started yet, my lord.
My lord, in fact, my lord, here, what had happened is, my lord, in fact, one additional charge sheet was submitted on, my lord, 23.
When will you complete the proceedings?
Lordship will give us a reasonable time, my lord.
Why this insistence, just a minute, why is this insistence on keeping him suspended? He's a doctor, you have acknowledged his skills,
No, my lord, he was,
and he was on leave. Suddenly you ask him to come back, his father had suffered esophagus cancer.
my lord, he was under, my lord, behind the bars, my lord.
You are
till
a model
February,
employ- you
February
are a-
2025, my lord.
Mr.
My-
Gogoi, you are a model employer. You can't behave like
Yes.
this with your
Lordship will give us a
doctors.
reasonable time, it will be concluded, my lord, I assure, man.
It will be concluded by which time?
A reasonable time, 3 months, my lord.
Concluded by 3 months,
Lordship.
or else we pass an order revoking his suspension. We'll say that the OM of 2024 is not being interpreted properly.
My lord, the
And
last,
how can you relate it back to the date when the charges have, it starts running from the date of suspension?
No, my lord, the Ajay Chaudhary says, my lord, within 3
Ajay
months.
Chaudhary says something else. You have read it differently. Now, give us that paragraph. It says on the fixing of the charge.
Yes.
Now, that is always, when Ajay Chaudhary was being decided, the Supreme Court was of the view that it is always contemporaneous. The moment you start the proceedings
Yes.
by furnishing charge, therefore the date of suspension is counted. It was not like when Ajay Chaudhary was decided in 2015, the situation was not like this.
My lord.
When you suspend a person in contemplation of a departmental proceeding and you
Well-
take 6 months to decide whether departmental proceeding has to continue and you keep him under suspension. You can't do this.
Well, he has not responded to the additional charge sheet, my lord.
no, I have
But
filed a response.
subsequent-
Whatever it is, you complete. You
Well,
say that
within
he is
3
not
months.
responding, we are proceeding.
Lordship will give us 3 months, my lord, we will complete. My lord, may record my part, I will convey to the authority.
In paragraph 10 of the
give you-
judgment,
We give you 1 month extra,
My
a
lord,
buffer
I'm
of 1
obliged.
month.
my lord,
But complete it within 4 months, otherwise we revoke the suspension using our own intellect to deal with this judgment.
I understand, my lord, within 4 months. my lord.
Yes, I think that should satisfy you.
my lord, in the paragraph 10 of the judgment, the learned single judge, my lord, held that, my lord, periodic review should be done within a period of 3 months. But in my case, my lord, though periodic review was not done, the suspension order was allowed to be continued. That is perhaps, my lord, perhaps purpose are contradictory, my lord.
This is periodical, sir, periodical review.
Yes, my lord.
Because of that OM, it is 6 months. First within 6 months, and then after
No,
every 3
That,
months.
that has been misunderstood, my lord. The OM says the first review should be done within a period of 3 months. Second review is 6 months, my lord.
Oh.
Thereafter, my lord, the periodic reviews should be
No.
within
Just
3
a minute,
months.
let us see let us see.
I have given a
this-
compilation, my lord. Also, will get the OM also in that compilation, my lord. Judgments also I have given, my lord.
You have given judgments where?
Along with the written argument, my lord.
Now, Ajay Kumar Chaudhary, we will, where is the OM?
OM is, my lord,
108. on the company.
OM is page 14, my lord.
Page 14.
14, my lord.
Hmm.
Second paragraph also will see,
Yes.
It is therefore directed that all the senior most secretaries of all the departments shall ensure that memorandum of charge sheet is served on the delinquent officer employee before the expiry of 3 months of period from the date of issuance of the order of suspension. This shall also ensure that the currency of suspension order should not extend beyond 3 months if within this period of memorandum of charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served within 3 months of suspension, a region order must be passed for extension of the suspension, which whenever necessary.
No, so therefore your charges were served upon you.
Within 3 months it was
Within
served.
3 months.
They have to, my lord, pass a
just-
region order.
Mr. Saikia, please answer the question one by one.
My lord.
Now, you were suspended when?
Well, I was placed on the suspension on my lord 28/6/2024.
28/6/2024.
My lord,
You were suspended.
my lord.
Now, charges were served upon you on when? On
On
which date?
18/7/2024,
Within less than a month.
less than a month.
So charges submitted. So this first review is not necessary. Because look at this, if the charge sheet is not served, if the memorandum of charges is served within 3 months of suspension, a reasoned order must be passed for extension.
My
So
lord.
therefore, by the end of 9th month, there had to be a review. Correct.
No, my lord,
Oh,
I have
Mr.
understood,
Saikia,
my lord. If the
I'm so
memorandum
bad in
charge-
mathematics with numbers. You are not expected to be as bad as me.
My lord, if the memorandum of charge sheet is served within 3 months of the suspension, a region order must be passed for extension. So within 3 months, my lord,
For
they have to pass
extension.
my lord,
So
they have to pass a order, my lord, region order for extending the suspension order. The first
served within 3
extension.
months of suspension, a reasoned order must be passed for the extension of suspension wherever necessary.
Yes. When, my lord, about the second review, they
Then,
says
then in this case,
my lord,
because charges were served on you on 18/7/2024,
my lord,
the date would be reckoned from this date. So first 3 months, I think it's those, no?
1810, then it will be 1810, my lord.
So for second is 6 months. But within 3 months, extension. Language is different. Is served if the memorandum of charge sheet is served within 3 months of suspension, then also a reasoned order has to be passed for extension of suspension.
Yeah, that is within 3 months.
So
First review.
proceeding begins, but after 3 months, so this 3 month would be counted from 28/6/2000.
Even if, my lord, it is
Now we are full.
Lordship will see the fourth para of the OM, my lord, fourth para. After issuance of memorandum of charge sheet, the senior most secretary shall
That's all
undertake
it
a review within 6 months. That 6 month review was made, my lord.
That 6 months review has been made,
After,
but the first review has not been made.
it says, my lord, wherever necessary. My lord, Lordship
Does
will
that-
see
does
that
that-
part, there will have to be something that it is.
I'll tell you what is the meaning of wherever necessary. It means that within that time you complete the domestic inquiry. If you cannot complete, you have to pass an order for extension of suspension.
My lord.
Correct. And then from that review, another 6 months, so 9th month.
Yes, sir.
But here, my lord, in fact, 2 reviews have been done, my lord, and we have,
We are not concerned with that, but you have not completed, you have not started.
my lord, within 4 months, it will be completed. I assure Lordship will record my,
It's his fault. For this, you keep a doctor suspended.
my lord, the
My lord,
charges are grave, man.
My
Charges
lord, the
are grave.
scene behind is that, my lord, I have a dispute with my wife. Wife is a powerful person, my lord. Her mother was a, my lord, MLA. Both of them, my lord, lost complaint against me. And that is why, my lord, this is the, my lord,
Then
outcome.
if you fight with your wife, you must face this.
My lord. That is the problem, my lord.
For whatever reason. Then what we can do is we
My lord,
direct them to complete
I
the inquiry
give the
within,
undertaking.
within 4 months.
My lord,
Failing which the suspension order shall be revoked.
since the date of suspension, my lord, I have not been paid the subsistence allowance. I have not been allowed to practice. My lord, I am They're facing penury now. my lord.
Practice, we may not ask them to permit, that would be subject to the rules. But then, the difficulty is that the charge against you, that you took leave on the ground of your father's illness and you went and joined as CEO of a private hospital.
No, that is not true, my lord. That I have, my lord, replied there.
Have they served you with that charge?
They have served. They have served with that charge. I have denied that, my lord. There is no.
No,
my lord,
denied that, but your denial must be acceptable to the disciplinary authority. We'll see that.
There is no evidence.
So it is
that
yet to be
I am
decided.
serving-
We can't then permit you to practice. We can't then coerce them to allow you to practice. We can only say that you get your subsistence allowance in the meanwhile.
Yes.
And if within 4 months to be counted from today, if the inquiry is not completed, your suspension shall be revoked.
My lord.
We do that only. Take them.
my lord, more than almost 1.5 years, my lord. Lordship may give the time, a lot lesser time. my lord.
You have waited less than 4 months would be.
Well, I am wait-
They asked
I am-
3 months
I
only.
am
I have-
approaching this honorable court since my lord, September 2024, my. Sir,
take. ये तो उठता ही नहीं है. The appellant has questioned the judgment dated so and so, dated 11/11/2025, passed by a London single judge of this court in WPC number 5645 of 2024, refusing to interfere with the continued / prolonged suspension of the appellant during the pendency of the domestic proceeding initiated against him. The appellant had contended before the London single judge that he had been suspended on 28/6/2024 on the imaginary charges, but the charges for the departmental proceeding was served upon him on 18/7/2021. However, the suspension order was not reviewed within 3 months of his having been suspended, as mandated by judgment of the Supreme Court in Ajay Kumar Chaudhary versus Union of India and others, 2015, 7 SCC 291, as also the OM dated 4th of February 2020, issued by the Department of Personnel, Government of Assam. The learned single judge found that there were 2 reviews of the suspension order, and the date of review shall reckon only from the date of issuance of charge and not from the date of suspension. Be that as it may, the Land Council for the appellant has submitted that till date, even after the appointment of the inquiry officer and the presenting officer, the inquiry has not begun, and the appellant has remained under suspension for more than 1.5 years. He has also not been paid his subsistence allowance and has been prevented from undertaking private practice. The facts of the case are that for a medical emergency in his family, his father's esophageal cancer and mother's diabetes and dementia, the appellant had applied for 75 days of earned leave for taking care of his parents located at Delhi. The leave was allowed and he was permitted to hand over the charge. However, later, he was abruptly asked to return. He requested the authorities to convert his leave into unpaid leave, but he claims to have been suspended on the false charge of his having taken up the assignment of CEO at a private hospital. This is one of the charges against him in the departmental proceeding. Mr. Gogoi, learned advocate for the state, learned additional advocate general, submits that there have been regular reviews of the suspension order, but considering the delay in conclusion of the departmental proceeding, he submits that in all its probability, the departmental proceeding shall be concluded positively within a period of 4 months, failing which the authorities shall contemplate of revoking the suspension of the appointment. Taking into account the aforementioned undertaking by the additional advocate general, we close this appeal with a direction that if the departmental proceeding against the appellant is not concluded within a period of 4 months, to be counted from today, his suspension order shall be revoked, and that during the period that he remains under suspension, he shall be paid his subsistence allowance with all the enhancements which are permissible under the rules. The appeal stands disposed of accordingly.
My lord, one more observation, my lord, if I may pray, my lord, he will cooperate with the my lord authorities.
Subject to the full cooperation of the appellant in the department.
My lord, the payment of subsistence allowance, the time may be my lord, fixed, my lord.
इसको हमारे पास देता.
My lord.
Yes.
For payment of subsistence allowance, my lord, they may be directed within this month, my lord.
Pay them with subsistence.
They are not paying, my lord. They are not paying, my lord.
We are not fixing any timeline for that. They shall pay. We have said that. We have said that.
My lord.
You must have done something really wrong towards them.
My lord, I have not done anything wrong to the government, my lord. Maybe with the wife, my lord, I have some dispute. And because of that, my lord, I am suffering, my lord.
All right.
Item 22.
Item? We have come to that.
May I plead your lordship? Yes. Lordship, respondent authorities planning to Bharatmala Road and Bridge, my lord, at Kalinagar in Hailakandi district, my lord. Already existing, my lord, one bypass is there, my lord.
You have a choice there. Can you have a choice there?
No, my lord, destroying the existing bypass and as well as, my lord, one school is there.
You are not inclined even to issue notice to the state.
My lord, one school is, my lord, high secondary school is already there, my lord. They are demolished this school, my lord, already. At least notice maybe you should, my lord. At this stage, my lord.
This is something, and this is a frivolous litigation. We don't appreciate. I mean, don't appreciate this means we don't appreciate the facts of this case. I mean, this doesn't goad us to sort of even issue notice to this. You are? What is your name? We have heard MS L. Wazida, learned advocate for the petitioner. Stop. This public interest litigation has been filed expressing grievance against the proposed alignment of Bharatmala Pariyojana Phase 1 road project, a national initiative to upgrade and construct highways for better connectivity. MS Wazira states that the decision to straighten and upgrade the old abandoned PWD road from Salchapara to Katakhal, bracket passing through Kalinagar, bracket close, along the banks of Barak and Katakhal rivers in Hailakandi district is not a correct decision. For the reason that this stretch of land in the Barak Valley is the most troubled part of the area. It is located near the confluence of two erosion-prone rivers, threatening the infrastructure in a huge way. The contention of the petitioner is that, in fact, the road should have been constructed on the bypass road further west of the already selected area, already selected road, which will avoid the vulnerability of the road against floods in the rivers. It has also been contended that the bypass road, which has recently been built, is in a good condition. And if that bypass road is chosen, the travel distance also would be shortened. It would be good for connectivity because it shall connect important villages like Algapur, Mohanpur, Uttar Narayanpur, and Hailakandi effectively. There is a already constructed flyover over the railway line. Thus, the contention of the petitioner is that the Bharatmala road project could have been easily aligned or widened along the safer bypass, eliminating erosion risks without any additional costs or disruptions. After having heard the learned counsel of the petitioner, we are of the considered view that this is not a matter requiring interference by this court in public interest. The government in its Department of Road Construction / Bridge Construction is the best judge to choose the area for concluding for carrying out the project under Bharatmala Pariyojana Phase 1 road project for increasing connectivity. There is no claim of the already selected road to be bad on account of it not connecting the villages in question. It would be the obligation of state to make roads which shall endure the vagaries of nature. In such matters, the choice is of the state, which in turn is based on the considered opinion of experts. The opinion of residents of a particular area cannot guide the decision making of the state with respect to selection of site or construction of connectivity roads. Finding no merit in this petition, we dismiss it, but without any order as to costs.
Oblige, Your Lordship.
Item 24.
My lord, limited prayer, my lord, section 14 SARFAESI application.
My lord, this has not been disposed of district magistrate, page 69, my lord. My lord, my humble prayer, my lord, action may be given.
There are times when even innocuous orders passed by the
My
courts
lord, this is a big
will
problem.
show notice.
My lord, lordship, may I pray one thing, my lord, only one humble prayer, my lord, because my lord, there is no any dispute to that effect. Only direction if lordship give that in a suitable time, they will take action, my lord, under section 14. But it will helpful, my lord. Otherwise, it will again be pending for a long time, my lord. Serve no any good purpose. RDGN case is very much clear, my lord. Lordship, RDGN case is very much
Yes,
clear.
Ronko, jaldi.
It clearly indicates that 60 days is the outer limit in RDGN case, my lord.
All right. We have heard Mr. S. Shamarial, an advocate for the petitioner, and
S. Sharma, sir, if I may humbly draw your lordship's attention to section 14, subsection 1, the proviso there too. My lord, the petitioner has annexed everything other than that affidavit by the authorized officer of the bank.
Everything given, there is no dispute. my
That
lord.
is not.
No,
there,
we
my
have
lord.
given, my lord, that everything is
That
there.
affidavit is missing. in these.
They will consider, my lord.
I will obtain instructions. However, my lord, in the same R.D. Jain's case at paragraph 23 thereof, the Honorable Supreme Court says that adherence to this proviso is mandatory, the last.
that's right.
And that he has not placed.
Altogether, there are 14 items which have to be supplied. The information regarding it.
Yes, my lord. But there is no dispute, my lord. I think.
Give it.
Yes.
Why can't you give that?
I will place.
Take them. The petitioner, we have heard so and so for the parties. We have heard so and so for respective parties. Naam likha diya. The petitioner is the auction purchaser. So in fact, the property in question was mortgaged to secure a cash credit loan by the borrower. The loan went bad. The borrower defaulted, and therefore the Canara Bank / respond number 3 initiated recovery proceedings under the SARFAESI Act. Symbolic possession of the property in question was taken, and the same was auction sold to the petitioner, he being the highest bidder for the property. There was sale confirmation by Canara Bank, but the property could not be handed over to the petitioner for the reason of no physical possession. In fact, the borrower and others had challenged the entire auction process before the Debt Recovery Tribunal at Guwahati, in which a stay order had been passed, halting the bank's ability to enforce physical possession before handing it over to the petitioner. Ultimately, the tribunal dismissed the claim of the borrower in September 2025, upholding the action of the bank under sections 13.2 and 13.4, 13.2, 13.4 and 13.8 of the SARFAESI Act, including the validity of the auction notice and sale. Next, following this decision of the tribunal, the bank / respond number 3 immediately approached respond number 2 under section 14 of the SARFAESI Act for facilitating the taking of physical possession of the property. The allegation of the petitioner is that respond number 2 has remained unresponsive even till date. There is there is a grievance against the bank as well for showing lethargy in following up this matter. Following up this matter. Mr. M.S. Sharma, learned advocate for the respondent, submits that under section one necessary document has not been furnished by the bank for positive action to be taken under section 14 of the SARFAESI Act 2002 by respond number 2. She submits that if all the documents are furnished along with the application under section 14 before the competent authority, all steps shall be taken for according physical possession to the bank and ultimately to the petitioner. Considering the aforementioned undertaking on behalf of the state, we close this petition with the expectation that in case all documents are furnished within a period of all documents are furnished by the by bank respond number 3 within a period of 3 weeks from today, necessary steps shall be taken by respond number 2 towards taking over the physical possession of the club.
That action time limit may kindly be given.
3 weeks. Got a question. Life.
My lord, another case we are coming on by another bank. My lord, this problem now getting up, my lord.
Yes.
Item 25.
Similar lordship, section 14. Here we have annexed the affidavit also we have submitted to Kumar.
Yes, what do you have to say here?
I'll obtain instructions.
I have submitted the affidavit and the application.
Despite the petitioner / Bank of Maharashtra having furnished all requisite information as required under section 14 of the SARFAESI Act, no steps have been taken by the concerned authority to facilitate the taking of physical possession of the secured property. Let notice be issued to respond number 1. Respond number
2 to 4, my lord. I appear for.
Let notice be issued to respond numbers 2 to 4.
Commissioner and Secretary to the
That's all right.
government.
2 to 4.
Yes,
Sharma, learned government advocate. You're a government advocate.
Yes.
Learned government advocate accepts notice on their behalf. She submits that after taking instructions from the concerned respondent, she will get back to this court by the next date. Obliged. Re-notify after. We are keeping it in February 1st week. Obliged.
6th of February. 6-2. Item 32.
Item 32. 30 हो गया.
32.
Oh.
We have filed our affidavit.
What have you said? What did we ask you to do? Let us see. Just a minute, let us go through our short. Point number 1, क्या है ये? ये for the appellant कौन है? State of Assam. अच्छा. Yes, what were the guidelines prior to 2008?
My lord, the affidavit that we have filed, my lord,
And there is an annexure, my lord, in page 147. If I may read the relevant portion of my affidavit, my lord, that the lordship may find at page 142, I suppose.
140?
142, my lord. That is the affidavit filed as per the instruction of this court. If I may take your lordship to page 144, paragraph 7. Has your lordship got in?
Yes.
May I read, my lord?
That we have noted down. That we know. The guidelines of 2022.
No, it has been modified. This is the modified guidelines in 2025. In 2025, it has been modified. Yes, page 147 is the modified guidelines and 148 also, that is the modified. Well, if lordship can come to page 150, it's remaining same. It has permitted now, my lord. If your lordship can read 147.
Yes, read.
These guidelines shall come into effect from the date of their notification by the existing provision in point number 5 of the guidelines and modified guidelines in right hand side column. These guidelines shall come into effect from the date of their notification by the UGC, provided that two academic programs pursued simultaneously before issuing of these guidelines in accordance with the UGC first degree and first degree regulations, statutes, ordinance of the university is concerned, and by following the norms prescribed by the statutory professional councils and the distance education councils of the Distance Education Bureau of the UGC, wherever applicable, shall be treated as valid. Now, my lord, if I can supply a copy of the 2003 regulations issued by the UGC regarding the admission, my lord, that does not say anything about the pursuing 2 degrees simultaneously.
Permissibility.
Permissibility, it does not say anything. Man. I'm providing a copy to you.
No, with this modification, it means that this no retrospectivity to the UGC has been done away with.
Done. That overcomes the whole thing.
Yes, so we do not make any difference.
Provided that, Lordship, my lord may kindly peruse that particular annexure, page number is not given me, otherwise I can lodge that UGC.
No, just now I've written 147.
Page 147.
Let us see now what is the issue.
Page 147. Lord.
1 second. Karuna Chapan was appointed. Just. Got it. Mark तो कम दिया therefore 5 was the point. Yes, who appears for respond number 7? Are you interested? Are you interested in joining the post? You're working somewhere else?
No,
No. She's the respondent.
I am responsible number one in the, I am the petitioner.
You are the writ petitioner. Who appears for respond number 7?
No.
We have not issued any notice.
No.
Notice
But response number 7 has been made party here. In the appeal.
has not been made a part.
No. In fact, the appeal was, I suppose, my lord, appeal was to be filed by the governing body as well as the selection committee, because the election was given. to the selection committee. And after the selection committee recommends, it has to go to the director, and then director has to take a call. Otherwise, the director as well as the government has come to the before my lord, for filing by filing this appeal. But the direction was only for number 3, 4, and 5.
For them, it is premature.
For that, it is premature. Secondly, my lord, I have made the party respondent in the writ petition matter. Those were not made party respondents here, my lord. That is there. Thirdly, my lord, response number 7 has already been.
Post remains vacant.
My lord,
Post remains vacant. Otherwise, I mean, if the earlier decision would have been allowed to continue, then respond number 7 would have got the job.
otherwise, my lord, Ratna Sawan has already been got appointment, and that appointment has been given by the director in the DC college informant. I have annexed that document.
Lordship, we are came before this honorable court because Lordship, if that be done, Lordship, it will
No, we
affect
are
the whole process.
We are not interested in deciding the issue with respect to just a minute,
Lordship.
with respect to permissibility or impermissibility of pursuing 2 courses. We are not concerned with it.
Lordship.
For the reason that the respond number 1 claims not to have been marked for a PhD degree.
Lordship.
This litigation has started.
Lordship.
Now, before we pass any order with respect to this, we are not going to say that, no, this was not a lot of marks. If we pass any order, we have to hear respond number 7 as well.
Even Lordship, other
Why
candidate,
have not been pleaded here, Mr. Gogoi?
Lordship, that part, Lordship, some mistake was done by us, Lordship. Otherwise, Lordship,
After some arguments, Mr. Gogoi, K. Gogoi, learned advocate for the appellant, seeks permission to implead. She was respond number 7 in the writ petition.
Lordship.
Implead so and so, take the name, / respond number 7 in the writ petition as respond number here.
3 will be 3.
Respond number 3 as respond number 3 in this writ appeal. Permission is accorded. Let a fresh memo of parties be filed by the appellant within a period of 2 days, filed in the registry within a period of 2 days. Let notice also be issued to respond number, newly added respond number 3 on steps being taken by the appellant within a period of 1 week thereafter. I mean, 2 days and 1 week thereafter. Both modes returnable in favorability.
Lordship, I have a small pair, Lordship. We want to file a reply against the justice affidavit. Yes, because clarification come from the university, Lordship.
Why our permission to file your reply? Do that.
13 February.
We are not saying anything because the respond number 7 has not come here.
13.
I mean, respond number 3 here has not come here. Let's see, respond number 1 is here.
Lordship. Even Lordship, we go by the marks, Lordship, and above him, Lordship.
See,
Lordship.
let us see whether if newly added respond number 3, let us refer to her as respond number 7. If respond number 7 is not interested,
then he will not come within the ambit, Lordship. Yes, because above him another 3 persons is there, Lordship.
Whatever it is, let's see what is the.
Lordship. Even Lordship, regarding the simultaneous degree part also, Lordship, we have received the clarification of the university concern. Lordship.
Yes.
Item 33 and 34.
Yes, Mr.
Lordship, other side is not here, otherwise I can begin, Lordship. They filed affidavit, Lordship.
We can't hear one matter twice.
Lordship.
Who appears? Dr. G.J. Sharma.
They filed affidavit. Lordship may post after vacation, Lordship.
Mr. B. Chakravarti, Learned Senior Counsel, Learned Standing Counsel, CGC, present. There is no appearance on behalf of the respondent. Even though, yes.
Well, I filed my affidavit. The issue is short as to whether the scheme 1991, that is for stagnation, the scale was uplifted from 1200 that time. That was not applied in the given to this respondent in both the cases.
We will fix a date for hearing of this. Let this matter come up. Wo kar dena ho.
10th February. 10th of February.
10th of February.
Item 35.
Yes, Mr. Boyan.
My lord.
Rule 28.
Rule 28, my lord, is in conflict with the original rule of 15, my lord. That is the case, my lord.
Take us to Rule 15.
My lord, in my petition, my lord, I have quoted, my lord may be pleased to find.
Rule 15.
My lord, page 21, my lord, may kindly have a look. Rule 15, recruitment to the post of assistant headmaster, assistant superintendent and procedure thereof.
This is Rule 15 of which rule?
My lord, this 2018, the Assam Secondary Education Provincialized Schools Service Rules 2018. The post of assistant headmaster of a high school and the assistant superintendent of a high madrasa shall be filled up by promotion from the candidates amongst the graduate teacher of the same school on the recommendation of the district promotion committee, so and so. Eligibility for the post superintendent madrasa, as the case may be, he must be BA, BSc, BCom from any recognized university, and he must have at least 10 years of teaching experience as a graduate teacher in high school / high madrasa. In case of amalgamated high school, the headmaster of ME, MB school is eligible for selection as assistant headmaster, subject to the condition that the incumbent should have at least 5 years of experience as a headmaster in ME school, if he is a founder headmaster, and 10 years of experience as a headmaster in ME school if he is not the founder headmaster of the ME school, if otherwise eligible.
What is ME?
My
Middle English.
my lord, upper primary schools, my lord. In case of high school having amalgamation with ME, MB school, the assistant teacher must have degree qualification with 15 years of continuous service in amalgamated school together with ME/MB school. In case of high school having amalgamation with LP school, the teacher of erstwhile LP school having degree qualification and 20 years of teaching experience in both LP and amalgamated school may also be eligible for selection as assistant headmaster if otherwise eligible. Now, my lord, this rule 28 has been incorporated, my lord, pursuant to a policy of the government, my lord, regarding that amalgamation under the Shiksha Kshetra scheme, my lord. Now, this while, my lord, incorporating this policy, what they have done, my lord, those persons, my lord, who was holding the post of, my lord, headmasters in ME or MB school, my lord, if they were undergraduate also, my lord, they have been given.
Who appears for respondent number 5? You are appearing for respondent number 5?
No, my lord, respondent number 5 notice has not been issued. my lord.
Let notice be issued.
Yes.
Why did you not point it out to the court
My lord,
on
actually,
earlier occasion?
no, my lord, actually, it is also a
It is coming for the first time.
No, my lord, many time it has already.
So you don't.
Yes, my lord, I should have, my lord, but my lord, while initially moving the petition, my lord, at that time, my lord, this court, honorable court has held that his presence may not be required.
Yeah, we have heard, Mr.
Well,
Whose presence may not be required?
this private respondent, my lord.
No. Who says so?
My lord, in the very first occasion, my lord, no, not my lordships, my lord.
Mr.
The
A- we
predecessor
have heard
bench, my
Mr.
lord.
A.R. Bhuya, learned advocate for the petitioner, and Mr. Khatniar. Mr. Khatniar is there for respond number?
1, 2, and 3, my lord.
Respond number 1, 2, and 3. The petitioner has challenged the constitutionality of Rule 28 of Assam Secondary School, bracket Provincialized Schools Service Rules 2018, which governs the amalgamation of schools under the Shiksha Kshetra scheme on the ground that it is arbitrary, discriminatory, and violates Articles 14 and 16 of the Constitution of India by allowing unqualified individuals to be redesignated as assistant headmasters after a school mergers, bypassing the merit-based eligibility criteria in Rule 15 of the same rules. Additionally, Mr. Bhuyan seeks quashing of subclause 8 of clause 7 of the office memorandum dated 3rd of August 2021, which mirrors Rule 28, and an order dated July 29, 2022, issued by the Inspector of Schools, Morigaon, redesignating respond number 5 / Safiqul Islam, who is only a higher secondary pass without a graduation degree and does not have a graduation degree, as assistant headmaster after removing the petitioner from the post, despite his qualification of BSc graduate over 30 years of experience. Who says that respond number 5 is not a party? Have you filed your affidavit?
Yes,
Mr. Khatniar has
my book lagi.
for response number
1, 2,
counter affidavit on behalf of response number 1 to 3 is on record. Let notice also be issued to respond number 5 on steps being taken by the respond number 5 is still holding that post of headmaster.
My lord.
Let notice be issued to respond number 5 on steps being taken by the petitioner within a period of 2 weeks, both modes, returnable March.
My lord.
March. Item 37, supplementary list,
They did not hear the date.
9th of March.
Wait, please, Your Lordship.
This was the case you mentioned yesterday.
Yes, madam.
Yes.
Lordship, I may take your lordship to page 20, the impugned order, my lord.
Page 28.
20. If I may give a brief facts, my lord. In 1991, the land was settled with with one Sunil Ranjan De. Subsequently,
Land was settled with
Sunil Ranjan De,
your father-in-law.
father-in-law.
Say that, no?
My lord. So,
That has an important bearing.
thereafter, my lord, what happened?
Your husband is alive, no?
Yes.
All yes.
So, what happened thereafter? The possession was also handed over in 1990.
Give us the dates.
My lord. Settlement order was passed in 29/10/1991.
Settlement order was passed in
29/10/1991.
29/10/1991 in favor of the father-in-law of the petitioner.
Sunil Ranjan De. And possession of the land was handed over to the settlement holder on 3/4/1992.
3/4/1992.
92. Now, my lord, thereafter there is no issues regarding possession or anything we are enjoying. In 2005, after the death of Sunil Ranjan De as well as his wife, my mother-in-law. The land was transferred in the name of the daughter-in-law for the purpose of actually getting loan from LIC. She's working in LIC. To facilitate that, the land was transferred in her name. And then permission building.
Transferred in 2005 only, before 2005.
2005.
2005 they died.
No, they died in 2001 and 2003.
Okay.
Before that.
Before death,
The transfer.
no, before death, they died in 2001 and 3. After their death, it was.
The husband, the legal heir of the settlement holders, the petitioner's husband, he transferred it by way of a sale deed in favor of his wife.
By
The
virtue of a
present
sale deed.
petition. Sale deed. And pursuant to that, on the basis of that, she applied for a building permission, which was granted on 19/9/2005.
19/9?
2005. Lordship will also notice that on 4/5/2005, for the purpose of obtaining the permission, I had also produced a trace map of the land. There also, there is no intrusion like that the same settlement order, which is in my favor, the trace map reflects the same thing. Now, in suddenly 2012, 2012, suddenly they, the Silchar municipal authorities entered into my land and started excavating a part of it. I come before this court, my lord, because this was without any notice, anything. Now, this court, in that writ petition, has said that since this is not a matter which can be decided by this court, it should be the settlement authorities would be the best authorities, and better, they have a direction to the municipal authorities that they should examine the matter, and after inquiry, after giving due hearing, some order should be passed. Now, while passing that order, pursuant to that direction in the writ petition, what the Silchar municipality had come up with a stand that no, there was a modification in 1992 itself. And that by virtue of that modification, a part of the land was, there was a 10-feet road was provided in this said modification order. Now, we don't have that modification order. Now, again, we come to the court, my lord, seeking the copy of the order. Now, this copy of the order was furnished to us on 8/3/2017 modification order. Now, since this order, this modification, whatever rightly or wrongly has been done as they allege, I have to challenge it before the settlement authorities. I go before the settlement authorities, my lord. I file a petition before the revenue authorities. They say, no, this is not the appropriate court. You go to the deputy commissioner. I approach the deputy commissioner. Deputy commissioner says that no, government has passed the modification order. So we are not the appropriate authority. At that juncture, my lord, I have come before this honorable court filing the third writ petition, where this impugn order has been passed. Now, my lord, the honorable single judge, while deciding this matter, has said that no, this because this settlement modification is is of 1992, and there is a presumption of government records, which is 30-year-old. He referred to section 90 of the Evidence Act. My lord, evidence. Although my judgment do not specifically refer to section 90, but he has said in paragraph number 23, if I may take your lordship to page. Yeah, page 31, my lord. Page 31, paragraph 24. The petitioner herein has stepped into the shoes of, lordship has got it.
Yes.
The petitioner herein has stepped into the shoes of the original settlement holder in respect of the subject plot only in the year 2005 by virtue of a sale deed purportedly registered in the year 2005. In the manner stated above, when the original settlement holders, Sunil Ranjan De and Manjushri De, despite having knowledge of the approval dated 30/12/1992, this, despite having knowledge means where from this has come, where did the honorable single judge get this, that we had knowledge? Because all through, my lord, my case was that it was done behind our back. And then, my lord, the revenue authorities.
Questioning the wisdom of the learned single judge. We are questioning you in the sense that what can be done. My question is this. Now, there is a settlement, there is a modification of the settlement.
They are alleging.
Many years pass by
Past.
and you are the wife of the son of the original settler or original settlement holder. Now, you purchase it for a reason because you are employed in
Because it
LIC
is-
or whichever company where loan could be easily made available to you. Now, can that be a ground for questioning the correctness of the modification?
No.
Now, knowledge, your knowledge may or may not be there, but if you come in the writ jurisdiction, if these aspects have to be decided, the courts will
My
relegate.
lord, I'll go to the appropriate forum. I don't have any
You can go to
difficulty.
the appropriate forum, but you should have gone up till now. But otherwise, in Article 226, the procedure is very perfunctory to decide these issues.
I know, ma'am.
In fact, the court would have done better by relegating you to the
That's right, ma'am.
appropriate authority and
That's
not
right, ma'am.
decided the
That
case.
was my limited prayer, madam, because Will.
No, this was not. This has got nothing to do with board of
because it has to be examined whether it was known to them or not.
You could have
This red court cannot
You
find.
could
I
have
know.
filed a suit impeding Board of Revenue and other persons as part.
But in
That
the
was the
meantime,
only
my lord,
way
the
if they were not
property,
appreciated.
property should be protected, my lord, in the meantime.
That
That's
is
it.
difficult. The memorandum has to be protected. The original agreement has to be protected. See, it's a question of making of road. You have constructed a boundary wall there, and therefore they want to demolish it. The maximum indulgence that we can show to you in this appeal is to extend the period for another 2 months, another 1 month. That's all. You can extend it for further period. We can.
And my lord,
We are very clear in our approach. Now we can't decide. It's a continuation of the writ jurisdiction. It's a continuation of the writ jurisdiction. These matters cannot be decided. I mean, especially the matter which you have red flagged is that you did not have any knowledge.
My lord.
Now this is
even
in
the
a writ
authorities, they are
jurisdiction.
not
This
able to
cannot be
show.
accepted for the reason that so many years have passed by.
My lord.
Your husband has bequeathed it. I mean, sold the property to you.
But my lord, the fact remains from 1991
And
till
you know that
2012.
that you purchase something along with all income.
All income, that's true. I understand, my
So
lord.
where would single judge find any other provision?
My
of
lord,
law
if
to decide?
section 90 is applicable.
Forget about section 90. The writ jurisdiction, why section 90? The
My
court was-
lord, that is
the court was very cautious, therefore it said so. In fact, if I were the court or he were the court, we would have relegated you to the appropriate forum. Do whatever you feel like.
My lord, I understand the limitations on the part of the writ court, my lord. That I understand. Only thing is this will affect wherever I go. The finding that there is a.
Ms.
that,
Chakravarti, we give you 30 more days or maybe 45 days.
My lord, can it be 3 months, my lord? Because getting injunction order, I don't
No,
know.
no, better to cede that property. you can have that. You can have the boundary wall demolished at your cost. Otherwise, the government will charge you heavily.
And my lord, we are enjoying this property from 91 to 2012.
Truth is,
And
so
then,
you have had
my lord,
you
are
have
they-
enjoyed the usufructs or the space for a very long time now.
And then
be content
record
with,
of right
be
also.
content with property which you have purchased.
My lord, record of right also says that do not reflect that it was modified or the 10 feet road is there. 2005, I obtained that trace map. That also do not reflect.
No, whatever you do, we are not asking you to vacate. You go before the appropriate forum. We can decide on this.
And let these findings not affect the any further proceedings.
Yeah, we will say
My
that.
lord.
We'll say that.
My lord.
We have heard MS. Any
I'm for the respondent six chairman.
no difficulty with this? We have heard MSP Chakravarti learned counsel for the appellant and so for the respondents. By the impugned judgment passed by a learned single judge of this court in WPC number 4748 of 2018. The appellant judgment. Yeah. the appellant has been directed to remove the obstruction / encroachment in the land and construction which was sold to her within a period of 30 days from the date of the passing of the order, bracket 18/11/2025, failing which it would be open for the respondents to remove the encroachment over portion of the land over which a 10 feet wide road was conceived of in the main settlement by way of modification. The appellant contends that the property in question was settled in favor of her parents-in-law, her father-in-law, in the year 1991. The possession of the land was given to him in the year 1992. Both the parents-in-law of the appellant died in 2001 and 2003 respectively. Whereafter the husband of the appellant inherited the property, who sold the same to the appellant by a sale deed in the year 2005. The appellant had obtained loan for constructing a house over the said land, and in the process had also obtained the trace map of the land. There was no indication to the appellant that the original settlement with her father-in-law was modified and a provision was made for a 10 feet wide road. In the land which was, in the area of the land which was originally settled with the father-in-law, with her father-in-law. The modification in the original settlement order was effected in 1992. An attempt was made by the respondents in the year 2012 to demolish a part of the building belonging to the appellant, standing over the area which was earmarked for a 10 feet wide road. This led the appellant to approach this court via a writ petition, but she was relegated to the settlement authorities for settlement of such disputes. There were the appellant continued litigating, challenging the correctness or the existence of the modified plan of the original settlement, but to no avail. Ultimately, she again approached this court after Board of Revenue having refused to exercise its jurisdiction to get into the issue. This court, the learned single judge, after having noted down the history of litigation, found that the parents-in-law of the appellant survived till 2001 and 3 respectively, but they had made no objection to the modified settlement order. Thus, presumption being in favor of the existence of the modified settlement order, providing for 10 feet wide road in the original plan of the transfer of the land in favor of the original settlement holder. since the property in question was sold to the appellant by her husband who had inherited the property, the appellant was expected to have the appellant got in possession of the property along with all the encumbrances and she is entitled to only that part of the land which exists as per the modified settlement as per the modified settlement order. The learned single judge modified order. The appellant is aggrieved by the learned single judge, drawing a presumption in favor of the existence of the modified settlement plan on the ground that it was never made available to her, nor was it available at the time when the trace map was obtained by her for obtaining loan. We are of the considered view that this issue could not have been adjudicated in a writ jurisdiction, and the learned single judge ought to have had relegated the appellant to the appropriate forum for a decision with respect to the existence and thus the validity of the modified settlement plan. Be that as it may, since the learned single judge did not interfere with the declaration of the respondents that the settlement order had been modified in the year 1992, he directed the appellant to remove the obstruction or / part of the building which stood over the land which was meant for a 10 feet wide road within a period of 30 days, failing which the respondents were at liberty to remove the same as obstruction. The appellant, if so advised, may approach the appropriate forum for the appropriate relief. But considering the factual circumstances, we direct that no demolition ought to take place within a period of 3 months to be counted from today. During which time the appellant may either seek the remedy before the appropriate forum or demolish the part of the property question, failing which the respondents will be at liberty to continue with their removal of encroachment right in the area. The appeal stands disposed of. That's the maximum that.
My lord, the findings in the learned single judge may not affect the.
Yes. We also make it clear that if the appellant moves the appropriate forum for settlement of grievances, the forum shall not be guided by the observations made in the judgment delivered by the learned single judge, and shall decide the issue on its own merits without giving full opportunity to the appellant to prove a case.